Welcome once again to Lehto's Law. Here's Steve Lehto.
Lewis sent me a note. So Steve, check out the story from the Ninth Circuit on arbitration. This is an interesting case from MSN.com. Ninth Circuit rejects Live Nation's arbitration appeal as unconscionable. Unconscionable. Ashley King wrote the story. The Ninth U.S. Circuit Court has upheld a lower court ruling that denied Live Nation and Ticketmaster's claim that customer antitrust complaints should be resolved through arbitration based on the terms of service when purchasing tickets. I've mentioned before, I've seen a whole bunch of shows lately. I think I've seen 11 or 12 shows this year, often buying tickets from these people, and someplace buried amongst all the verbiage of the various transactions is something saying that I had agreed to arbitrate any claims I might have against them. And so I haven't objected to that, but some people have. A ruling in a case called Heckman versus Live Nation ruled that Live Nation cannot enforce contract provisions that require ticket buyers to arbitrate their claims instead of suing them in federal court. The appeals panel called the arbitration rules unfair to consumers while being overtly beneficial to the defendants. I've mentioned before, if I'm going to allow you to pick the game and the playing field and the rules, you can win. So you got to be careful. U.S. District Judge called the arbitration clause procedurally unconscionable last year in his ruling after Ticketmaster changed its chosen arbitrator to New Era. He also called into question the ability to mass arbitrate cases grouped together, saying it would severely limit the plaintiff's ability to prove their cases in court. So the trial court ruling came last year. The Ninth Circuit just ruled. It is plain that it would be impossible for plaintiffs to present their claims on equal footing to Live Nation, the judge wrote in the Ninth Circuit opinion. Forced to accept terms that can be changed without notice, a plaintiff then must arbitrate under New Era's opaque and unfair rules. And so they say we get to pick the arbitrator. And we can change our mind as to who we use. We can use them, we can use them. It's up to us. So two judges agreed with that ruling, stating that the Federal Arbitration Act does not apply to mass arbitration contemplated by Live Nation's agreements. Live Nation says it disagrees with the Ninth Circuit ruling, arguing that the change of arbitrator is not unfair, unexpected, or otherwise unconscionable. We hold that the delegation clause of the arbitration agreement and the arbitration agreement as a whole are unconscionable and unenforceable under California law. So this is a California thing. We hold further that the application of California's unconscionability law to the fact that this case is not preempted by the Federal Arbitration Act, the FAA, different than the Federal Aviation Administration. Finally, we hold as an alternate and independent ground that the FAA does not preempt California's prohibition of class action waivers contained in contracts of adhesion in large-scale, small-stakes consumer cases. So the FAA and how it interplays with our arbitration would be quite lengthy and turn this video into more of a lecture series. I do have another channel called Steve Lehto's Second Channel. And on that channel, I put up videos once or twice a week on disparate topics, sometimes completely off topic. In the video today, because I often put up videos on Fridays, I will put up a video discussing how this impacted the lemon law in the state of Michigan. Very obscure concept. So if you're interested in the obscurities that I get into, go check out my other channel. The district court observed that Live Nation provided nearly all of New Era's revenue during its first year, and there appears to be a remarkable degree of coordination between the Live Nation attorneys and New Era in terms of their interpretation and the evolution of New Era's rules. And again, when one company says we use these people to do arbitration, and the company's paying the arbitrators, who do you think the arbitrators rule for? I mean, just take a wild guess. Finding these facts to be concerning, the district court noted this could certainly create an inference of bias. That's putting it mildly. It seems to me the circumstances in this case create more than merely an inference of bias. They create a strong and inescapable perception of bias, the judge wrote. A dispute resolution procedure is not an arbitration unless there's a third-party decision maker. A third-party decision maker whose interests are so allied with those of one party is for all practical purposes subject to the same disabilities which prevent party himself from serving. So you don't get to arbitrate your case and be the arbitrator, any more than they get to be the arbitrator. And so when they appoint somebody as an arbitrator and control them and tell them what to do, kind of takes the fun out of it. Not only is the line between Live Nation and New Era blurry, but more than that, this agreement would require a New Era arbitrator to decide the question of whether their employer's invention, developed with the help of the party in front of them, is a failure. The answer to that question is yes. Goodbye, New Era, and the arbitrator's job as an arbitrator with any arbitration provider forever. And so, going after Live Nation, Ticketmaster, and all those different kinds of companies is quite easy to do. There are a lot of people out there who are unhappy with them, including not just consumers, people who buy the tickets to go see the shows, but also the bands themselves will tell you that they don't like the way Ticketmaster and their cohorts handle the business of selling tickets. And just a couple of years ago, The Cure came to Pine Knob. And I like The Cure. I've seen them before. I wanted to see them again. And they said, well, we're going to run a lottery system, and you have to basically apply to get a place in line, and then you can buy your tickets. And I did that, and I was told, yes, you get to get your tickets starting 10 a.m. on this particular day. Get in line and see what happens. So I got in line, and it goes, you're next. Then it goes, you're up. Congratulations. What do you want? I go, I want tickets. And I went to the map where it shows all the tickets. I go, I want those right there. Not available anymore. Okay, I want those right there. Not available anymore. I'll take any tickets you got. Not available anymore. What do you want to do? I want tickets. Okay, tell us which ones you want. So Pine Knob has seating in the pavilion, and then they've got lawn seats. Literally thousands of people milling about on a lawn like cattle. But I was willing to do it for a show that I really wanted to see. It goes, would you like lawn seats? I go, yes. How many? I said 4. I type in 4. I'd hit enter. It goes, those 4 are not available anymore. What would you like to do? Well, are there any lawn seats available? Yes. I'll take 4. Now remember, when you're asking for seats that are identified down in the pavilion, obviously, if they don't hold them while someone's looking at them, which they ought to, I understand that those 4 seats could get purchased. Now I got to get these 4. Oh, but when you say there's thousands of tickets for the lawn, would you like 4? Yes. Those 4 are sold out. But do you want to buy 4 tickets? Yes. Those 4 are sold out. Which 4? Is the entire lawn sold out? Turns out it wasn't. And I talked to people who got tickets. I said, when did you get your tickets? They're like, 11:30. Eastern time in Michigan? Yeah. Okay, I was online at 10:05 and it was telling me that everything was sold out. Oh, no, it wasn't. It was probably heavy traffic on the site. But then here's the thing. There was such an uproar of people in similar situations as mine who thought that something was going wrong there. There's some reason that I can't get tickets, but they can. Don't get me wrong. I wasn't planning on suing anybody, but I was upset. I'm like, what's going on here? Some people pointed out that the service fees on some of the tickets implied that the company selling the tickets was making as much, if not more, per ticket than the band was. And I had read an interview, I believe Robert Smith said that they were going to do a tour and they're getting kind of fed up with watching what was happening because their fans would complain on the internet. I wanted to go see them, but the tickets were crazy expensive. So he had said, we're going to try to keep the ticket prices down. We want to do that. That was an active thing he said. I want to keep the ticket prices down. So when he and the band depressed ticket prices, the ticketing companies go, we don't care. We still get to charge our monstrous fees. And when that hit the news, after the show was sold out and people like me were complaining about it, the company involved in the ticketing came out and said, we'll refund some of those fees. We'll refund some of those fees. I'm not exactly sure how that all worked out. All I know is I didn't get to go see the show, okay? So that was a couple years ago. I don't know if I'll get to see them again. I don't know. But I've seen a bunch of shows this year, and I'm always baffled and amazed when I pull the ticket out and I look at it and it goes, okay, here's the cost of the ticket, service fee, this fee, double secret probation fee, taxes, the tax fee, the fee tax, and the tickets wound up costing some crazy amount of money. And now I remember when it was a convenient ticket corporation and you'd either go to a kiosk at the mall, customer service at Sears, or you could go to a travel agency. A lot of them had the machines there. And they charged a fee, but they hadn't yet figured out that they could charge as much as the band was charging. So I'm glad to see this happen because I have a problem with arbitrations that aren't fair. I have no problem with arbitrations that are fair. And I've had situations before where my client said, Steve, I don't want to wait a year and a half for a trial. Is there anything we do to resolve it now? And the other side goes, we could arbitrate it. I said, if we can pick an arbitrator that we both agree on that we think will be fair, sure, we've done that. I've done that before. I've done arbitrations. I've done a bunch of them. But the arbitrations that I don't like are where they say, oh, you filed a lawsuit? Tough. Your client signed this document way back here. They got to arbitrate here. We get to pick the arbitrator, the forum where it's going to be arbitrated, and we get to pick the rules. And I've seen it before where the rules are opaque at best and unfair oftentimes. So this is interesting, but the Ninth Circuit has rejected Live Nation's arbitration appeal as unconscionable as a matter of law. So this would imply that if you have an issue with Live Nation in California, you aren't bound by that arbitration agreement. So Ashley King wrote this. Lewis sent it. MSN published it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. On the form where it says, in case of emergency, notify, I put doctor.